welcome to the latest edition of our Breaking Ground series, a series of webinars really kind of targeted at those in the insurance and construction industries that have got an interest in claims against construction professionals. My name is Neil Howes. I'm a partner here at Mills and Reeve. Your other speakers today are Miranda Perks, who's a senior associate in our Birmingham team, and also Charlie Andrews, who's an associate in our London team. And one of the things that we all have in common is that one of our areas of specialism is defending construction professionals when they're sued for negligence. So today we're going to be talking about the first steps when notice of a construction dispute first lands on your desk. And we're going to be looking at that from two perspectives. So firstly, we're going to look at it from the perspective of the professional themselves and their broker. And then secondly, we're going to look at that and the same steps, but from the perspective of the professional indemnity insurer as well. Now, you might be thinking, well, why is this important? Well, I think probably for three reasons. Firstly, as we'll explain, the notification of a claim or a circumstance which is likely to give rise to a claim, that's the trigger for cover under a professional indemnity policy. Secondly, sometimes in construction settings, you get claims that are made against professionals many years after practical completion has taken place. But equally, you do sometimes get claims that happen and arise as the project is ongoing. And those need to be get to grips with quickly, just so that we can get the project back on track and hopefully minimize the damage which is caused. And then thirdly, and unlike in some other types of professional negligence claim, the timescales for responding for construction professional negligence claims are a lot shorter. So just some housekeeping before we crack on. Just a reminder that we are recording this session and it will be available through our website hub after the event if you want to watch it again. We're going to be doing some feedback at the end and also some polls, just a couple of polls at the end, just to look at how the things that we've been talking about kind of apply in a practical setting. So I think we've covered everything. What I'm now going to do is hand over to Charlie. Charlie, we're going to start by looking at the perspective of the professional and their broker. What is notification and why is it important?
Thank you, Neil, and good morning, everybody. As Neil has just said, the trigger for cover in a professional indemnity policy is notification. And it's really important to get this step right, otherwise it could affect your coverage position. So you'll look at your policy and it will ask you to notify both claims and circumstances. And these terms will be defined slightly differently depending on the policy, but broadly speaking, a claim usually means a written demand for monetary damages or notice, also in writing, of an intention to commence legal proceedings. Now that's pretty wordy, so let me break that down a little bit further. So proceedings, by which I mean a claim form, or an adjudication notice are obviously a claim, and so they need to be notified as one. The same is also true for a preliminary notice of claim, a letter before action, or a letter of claim. But remember that it doesn't necessarily need to be formal, it just needs to be written, and so an email will suffice if it either demands compensation or threatens legal proceedings. A circumstance is a little bit more nuanced, but it's often defined as something that may give rise to a claim, or perhaps something that is likely to give rise to a claim. Now, we lawyers could talk all day about the difference between may and likely to, but usually what needs to be notified is either a shortcoming that you have identified in your own work, which may cause your client loss, or some sort of problem has arisen and there is some suggestion that you are at fault. Now again, unlike a claim, this could be said over the phone, or it could be in an email, or it could be a letter. Circumstances are significant because claims made in the future attach back to the policy that the circumstance was notified to, even if you've since renewed with a different insurer. And please remember that even if you think the allegations are a load of nonsense, you still need to notify insurers. And also remember that a notification is usually for a specific problem or allegation, not the project as a whole, and not the entire claimant. And so if further allegations are made, these will need to be notified separately.
Charlie, we've looked at the why notification is important, but what about timing, and why is timing important?
Yes, so timing is important for 3 reasons. So first, the policy will set out notification timescales, and it will be different in each policy, but it normally says something along the lines of notify as soon as possible or notify immediately. The second reason that timing is important is something that you've already said, Neil, which is that construction claims often have very tight deadlines. So for example, if you receive a protocol letter of claim, your letter of response will be due within 28 days. Now, if you thought that was tight, with adjudication, the whole process needs to be completed within 28 days. Delay can mean missed deadlines, which can mean increased costs, but at its very worst, it can mean that you lose your opportunity to submit a defence in its entirety. And the third reason is that if a claim is made during the period of a policy, but not notified until after renewal, the insurers of the old policy may be entitled to decline the claim for being made after the period of insurance. And now you might be thinking, well, that's fine, because I'll just notify it to the renewed policy. But unfortunately, that may not work, because the new policy will probably contain an exclusion for claims or circumstances that ought to have been notified to a previous policy. And you need to take particular care on this point around renewal time, as the delay of only a couple of weeks may mean the notification falls between 2 policies.
So we talked about the kind of policy perspective and the importance of notification. What about other things? What else does the professional and their broker need to be thinking about right from the outset?
So it's important to remember that each claim will have its own facts, but generally speaking, I think the more you can do to explain the issues to your insurers, the better. And on the next couple of slides, I've set out a few do's and don'ts, which I think apply to most claims. So do explain what you're notifying and why you're notifying it. And alongside this, provide a broad overview of the project and who the key parties are. Now, you might have been up to your neck in this project for years, but remember that insurers haven't, and so things that are obvious to you may not be obvious to others. Provide your comments about whether you think the allegations have any merit, as this can give insurers a good starting point for considering liability and strategy, although do take care not to share this opinion with the other side. And explain to insurers what you think needs doing, especially if there are tight timescales. So for example, if you're aware that a response is required with a short deadline, tell insurers, as this may not be immediately obvious. And likewise, flag to insurers if you think there's anything that can be done to mitigate or minimize loss. And if you're being asked to enter into a standstill agreement, that's something that my colleague Miranda is going to come on to in a moment, again, tell insurers, as this may require urgent consideration. Preserve your documents. So we normally recommend taking a copy of all physical and electronic documents before you review them, as the review process can sometimes damage or corrupt the originals, and that's particularly the case with electronic documents. And finally, think about whether you need to notify other insurers. So for example, if there's been a personal injury, then your public or employer's liability insurers may need to be involved. And we've done a previous Breaking Ground seminar on the interplay between different policies, so do check this out on our website if it's of interest. And moving on then to what you mustn't do. So don't admit liability, even if it's really obvious, as there may well be defences that you haven't thought of. And it's important to note that if you prejudice your own defence by, for example, making an admission, then that could adversely affect the coverage position. Don't enter into any settlement negotiations without insurers' consent, otherwise insurers may not be obliged to pay the settlement. Don't disclose the terms of your policy. The claimant may ask for a copy, but generally speaking, they're not entitled to a copy. And please do not delete or destroy any documents. This is probably the biggest sin on this list. And whilst it may be tempting, especially if you find some really damning documents hidden in some email folder somewhere, I can tell you it really isn't helpful. And you may find yourself being accused of contempt of court, which in the worst case could mean a prison sentence. And as a little note for the brokers that are watching, it's your job to guide the insured through this process, and remember that this may be the first claim that they've ever faced, and so they may need a little bit of help with the process.
Okay, so we've been looking at that obviously from the perspective both the professional and their broker. The flip side of that is when the notification lands on the insurer's desk. So, Miranda, what are the key things that the insurer needs to be thinking about when a claim or a circumstance lands?
Well, so the starting point is to review the notification itself. Do you have enough information to understand what is being notified and why it has been? If the answer is no, then seek further information from the broker and or the insured at this point before going further. And then the steps can really be broken down into two different sections, so coverage and assisting the insured.
Okay, so we talk about about kind of starting to consider coverage. What's the best way of starting that? Is there a particular order of things that people ought to be following? How do you go about doing it?
Well, so there are no hard and fast rules here at all. So we've just come up with a suggested order for you. So step one is consider the scope of cover. So does the claim or circumstance notified fall within the scope of the insuring clause under the policy? If something has been notified as a circumstance, does it fall within the policy's definition? Is this a defined term? It might not be. So if it isn't, then ask the question, is this something which, objectively speaking, may or is likely to give rise to a claim in the future? And if it's not, you may wish to accept it, may wish to not accept it, pending receipt of further information. So then moving on to step two, consider the exclusions in the policy. Do any of them apply? Most PI policies will exclude cover for claims arising out of defective workmanship, but will cover claims arising out of defective design. And it's often not clear when a claim or circumstance is first notified whether the damage alleged to have been suffered is a result solely of a workmanship issue, or is a result of design, or is a bit of a mixture of both. And so it's quite common for insurers to accept the notification, but reserve their position until the picture becomes a bit clearer. So carrying on with some other exclusions here, most PI policies exclude cover for fitness for purpose warranties and other contractual obligations which impose a more onerous duty than the duty to use reasonable skill and care. So if the claim or circumstance notified is for a breach of contract or a breach of a collateral warranty, as it frequently will be, check whether the insured's contractual obligations go further than the obligation to use reasonable skill and care. Some policies may include endorsements or memorandum. And the most common examples which we're seeing now are ones that either exclude claims arising out of or relating to fire safety on buildings over 18 metres, or set a cap on liability. Many PI policies will exclude cover for claims and circumstances that the professional was aware of prior to the inception of the policy. So key questions to consider are, when did the insured first become aware of the issue which is now being notified? Was the insured aware of the issue prior to inception of the policy? If you think they might have been, it might not be covered, or it might fall to be covered under an earlier policy if it was notified to an early insurer. So step three, consider the conditions in the policy. Has the insured complied with the claims conditions and any other conditions which might be condition precedents to liability? And finally, step four, if the information provided suggests to you the insured might not have made a fair presentation of the risk, you might want to go back and review the proposal form and determine what other information you might need. It's important to point out here that you won't necessarily be able to answer all of these as soon as the notification is made. And this is just a starting point for your coverage investigations. And if you think it might be complicated or you want a second opinion, you might want to consider instructing solicitors.
Okay. So having looked at coverage then, at the outset you were saying the other side of things really is looking at what assistance the insured is going to need, right from the outset. So what are the key things there that insurers ought to be on the lookout for and bearing in mind?
Yeah, so at the same time as investigating cover, you'll also need to consider what advice and assistance you might need to be giving to the insured to ensure that their position is protected. And this might well be on a without prejudice basis if a reservation of rights is in place. So as standard, make sure the insured is aware that they're not to make any admissions of liability or enter into any agreements without prior approval, and that they're aware that they need to keep you updated with the progress of the claim at all times. Make sure the insured is aware that they need to preserve any documents they have relating to the project. And I would also suggest that at this point, you sit down and sketch yourself out a contractual matrix. So we've set out an example for you of one on this slide. So something like this. Construction claims are often complex, they involve a number of parties. So doing this will really help you get a better understanding of the project and where the insured fits in. And they're also really useful for identifying potential recovery options. So consider whether the insured might have a right of recovery against a third party. And then ask the insured for the contractual documents, so copies of collateral warranties and appointments and novations relating to these third parties. Consider whether there's a possibility that by taking action now, a claim might be avoided or damages reduced. Is there a mitigation of loss clause in the policy? And should insurers consider funding or part funding a remedial solution? Of course, you'll need to be certain about policy coverage is engaged before making this decision. And I know that in our first series, we did look specifically at mitigation of loss. So if you want to remind yourselves of it, it's still available via a link on our website. There may be some instances where the insured will need to act really quickly and will ask for your help. The insured might have been asked to enter into a limitation standstill agreement and might be required to provide a response within a really short time frame. And this is becoming more common, particularly in respect of claims relating to fire safety defects post-Grenfell. Limitation standstill agreements are often a good idea as they hold the position whilst allowing you to carry out further investigations in respect of the claim. But there are a few points that you just need to look out for in them. So check the long stop date, check whether it's a reasonable time period that's been suggested. Check to make sure that the standstill doesn't prevent the insured from being able to raise any limitation arguments which might already have arisen. And check how the dispute has been defined within it. So ideally, this should be specific and go no further than is necessary to hold the position. What you don't want is a wide-ranging definition covering all possible claims that might arise on the project in the future. Some other situations where the insured might have to act quickly is where proceedings have been issued or where they've received an adjudication notice. Now, both have really strict deadlines that need to be adhered to. So for proceedings, an acknowledgement of service will have to be filed within 14 days. And the insured will have to, in terms of an adjudication notice, the insured will have to provide a response within 14 days of receiving the notice. Generally, just consider what assistance you might need from solicitors. Each case will be different, but if proceedings have been issued or an adjudication notice has been received, instruct solicitors immediately.
Thank you very much. I think what is clear is that actually at the beginning, right at the beginning when things kick off, there is quite a lot to focus on, and probably more so potentially in construction claims than any other type of professional negligence claim. And I think the importance of this is hopefully to get the professional and the broker and the insurer all working together. So right from the outset, you've got the professional's position properly protected, but also, of course, in doing so, the insurers are protecting their position ultimately as well. So what we thought we'd do is kind of finish with a couple of kind of quiz questions or polls. And the first question, I want you to put yourself in the scenario where you're the construction professional here, and the problem that you've got is this. You designed a new building 3 years ago, and your former client calls you to explain that the roof is leaking, and they reckon that that is a result of poor design. You believe that the issue is down to actually poor workmanship on the part of the roofing contractor. So here's the question: what should you do? Should you notify this as a claim? Should you notify it as a circumstance? Or should you do nothing? This is neither a claim nor a circumstance at the moment. So if we could just start that poll. Well, nobody went for answer 3, and I think you're absolutely right. Bit of a split there between, is this a claim or a circumstance? I think probably on the facts presented, it's probably not a claim at the moment. There's been no demand for compensation. There's been no threat of legal action. There is a suggestion, of course, that that might follow. And I think that's probably why this qualifies as a circumstance. And it is something that should be notified, therefore, even though you as the professional think that actually the roofing contractor is responsible. Okay, so I'm going to stop sharing those results, and we're going to go on to the next poll. And in this scenario, I want you to put yourselves in the shoes of the insurer. One of your insurers has received a letter of claim and an urgent request to enter into a limitation standstill agreement. It looks as though the limitation date has actually already passed, and the insured also believes that its subcontractor is responsible for the issue which gives rise to the claim. So what are you going to advise your insured to do? Should you be saying, look, decline to enter into the standstill agreement because limitation has already passed? 2, enter into the standstill and then take no further action? Or 3, agree to enter into the standstill and investigate whether the standstill also needs to be put in place with the subcontractor? Let's have a look at what you think. Right, wonderful. Let me just end the polling there and I'll share the results. So actually, again, we've got a bit of a split here between 2 answers. 31% of you said decline the standstill because limitation has passed. 69% though say agree to enter in the standstill and investigate whether you need to put one in place down the line. I don't think there's any actual hard and fast answer to this one. I mean, I think there are circumstances where, because of a limitation argument that you've already got, you might decline to enter into a limitation standstill agreement. That said, limitation issues can often be more complex than at first appears. And of course, the risk by declining to enter into a standstill means that you could end up in proceedings. And I agree with everybody. Nobody went for the agree to enter into standstill and take no further action. I think that would probably leave you somewhat in limbo. But I think that the third option is probably the preferable one, is that have a think about whether a standstill is needed. But if you're going to do that, I think you need to make sure that that standstill is not somehow waiving any limitation rights that might already have accrued. So you just got to be a bit wary about some clauses that claimant solicitors sometimes chuck in that might do that, or alternatively insert a clause that just makes it expressly clear that you're not waiving those rights. But I think then it is probably worthwhile then having a look down the chain, because if limitation is an issue in the main action, then it might also be an issue and is likely to be an issue further down the line as well. So I do think it's worth investigating whether you need to put a standstill in place with the subcontractor as well. So that's all that we've got time for today. Thank you very, very much for joining us. We really love putting on these sessions, and at the end, as the seminar comes to an end, there will be a feedback form, and we'd love to get your feedback on this one, and also, of course, your ideas on future topics that you'd like us to cover. We're going to be back next month. I think it's the 17th of November, where our next session is going to be focused on letters of claim in construction professional negligence claims, and some top tips on the kind of things you need to be thinking about there and how to deal with them. But for the most part, and for this morning, thank you very much again to everyone who's joined us, and have a great day.